Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Hello, everyone. Welcome back to the Estate Blueprint with attorney Thomas D. Begley III, founder of Thomas D. Begley III, LLC in Morristown, New Jersey. Tom is a certified elder law attorney with more than 35 years of experience, helping South Jersey families protect what they've worked for through estate planning, special needs trusts, Medicaid planning, and probate administration. I'm SeanOConnor, and today we're talking about small business owners, the people who have spent years building something they want to keep in the family or pass on smoothly. We'll look at how estate planning protects the business, the employees, and the family behind it. Tom, good to see you.
Good to see you as well, Sean.
You know, when you're meeting with business owners in South Jersey, what are the biggest estate planning issues that you find get overlooked when it comes to their company? Because I'm sure you're connecting with people all the time.
Well, the biggest one actually is the lack of a plan for the business itself. Generally, I've seen people where they come in to get their estate planning done, and I think over the years I've found that in order to be good at estate planning, you need to understand business planning because, for lack of a better term, the businesses that people own may be one of the largest, if not largest, asset in their estate. However, a lot of people, they'll get a certificate of incorporation and maybe some bare bones agreement. And I've seen many without an agreement, and it's chaos when somebody passes away. So there's two things I generally see. One is no planning. And then the second thing that I see is poor planning. And poor planning often comes into the category of really, I mean, you hear about boilerplate a lot of estate planning or other areas of law, but I've seen really bad boilerplate often in the business planning. It's generally a simple buy-sell agreement that says if one person dies, another person's going to buy the other out, but it doesn't talk about anything in a realistic objective, and it doesn't have anything to talk about valuation. There's just a lot of issues that are overlooked that really need to be examined to make sure that the business plan first is adequate by itself, and then secondly, weaves into the individual estate plan, whether it be a will or a trust.
Got it. You know, you mentioned the chaos that inevitably ensues when there isn't a comprehensive plan in place. Can you mention a couple of specifics here? What happens, if a business owner does pass away and, you know, there's nothing appropriate?
I guess there's two big areas of dispute that apply for any business, whether it's family owned or not. And, that would be valuation and the period of time in which the interest is going to be purchased. And then there's kind of also a little bit of a wrinkle, and that is what if the person has the audacity not to die but retire? Now, so really there's three, and there's one that does specifically occur when you're dealing with family businesses, and that is how to handle generational planning when some members of the next generation are going to be in the business, but some are not. So I guess maybe for the first one, valuation is a big one. When somebody passes away, usually what I see in a lot of buy-sell agreements is just generic language saying that, we're either going to get it for X number of dollars, which is a valuation that they did when they opened up the business 20 years ago, which is not even remotely rated to what the business is rated now, or it doesn't say anything about valuation at all. So typically you want to have some language in there that talks about either a flat value, which you will keep up on an annual basis. And then the second is to get an appraiser that specializes in that area of the business, and to make sure that they are the ones that are going to come up with a value. A lot of people will have like the accountant for the corporation or one of the partners. Usually we won't tell people to disqualify those. I mean, the notion, it's a bit of a conflict of interest to have one person, if you're the surviving business holder, to provide an objective valuation of what the business is worth upon one owner's death, when that person's going to also determine whether or not he's going to continue the use of that account services moving forward. If you're going to do a agreed upon value statement, one of the benefits of that is if it's done on an annual basis, then it does take a lot of angst out of whether the independent valuation is appropriate or not. I try to do a blend a lot of times in my agreements. I'll generally say that if we are renewing the certificate of value for the business annually, that's fine. But we go more than 2 years without an updated certificate of value, then we would default to an independent appraisal. So that takes care of valuation. The other is, how do we get this bought out? So a lot of times what happens is, as we're younger, maybe we've got insurance where we can buy the other out, but sometimes people set up businesses when they're at an age where they're no longer insurable. And I've had the occasion where we're trying to clean up a mess right now. The business between two partners is worth $4 million. One of the partners passed away. The other partner has to buy him out. However, he doesn't have $2 million shaking around. And the guy that passed away was older and was not insurable. So generally, you should make a very sound determination as to what is a reasonable buyout. Uh, so a lot of times you'll say for like a basis that size, maybe it's done out over 5 years with an amortization of 10 years and have a balloon payout. But you want to do something because you're not first. You want to make sure that the estate gets paid, but the estate's not going to get paid if it's an unrealistic objective. And then secondly, the business might collapse if the person can't afford to make the payments. So it's a lose-lose situation you want to try to avoid. And then the third thing that they don't do is contemplate that somebody might not pass away, but they may want to just walk away. I've had occasions where there was proper buy-sell insurance in place, and it certainly would have made sense if one person passed away, the others could have no problem buying them out. However, one of the guys decided, hey, I'm 75 years old. I don't want to do this anymore. And, told the younger partner, it's time for me to retire. The terms of the buy sell said that, the guy was going to write the check for the entire buyout immediately. Fortunately, after some negotiation, there was some agreement that was made as to the buyout, which extended the period. But I can assure you that the guy that was retiring wasn't happy with the fact that he was going to wait longer than he thought he should. And the guy that was going to be keeping the business alive wasn't happy about the fact that he was going to have to pay out quicker than he thought he should. So at the outset, and I do this when people come in just after wills of trust done, if they have a business, they have to bring in a copy of the business agreement because I don't want to treat that as an independent piece of business. If I'm going to overlook the business outside of its mere value, I believe I've committed malpractice at that point.
Yeah, it's got to be treated holistically for sure. I know we're talking mostly about family-run businesses. How do you help your clients balance fairness among children, right? Because sometimes none of them want to be in the business. Sometimes some do, some don't. How do you mediate that situation?
That's really dicey. Every so often you get the case where all the kids are involved in the business, and mom and dad want to see the business continue through the generations. And occasionally it does work, but the failure rate of generational businesses is extraordinary. It's about 70% of the second generation businesses fail, and third generation it's 90%. So in order to try to not be rather to try to be the exception rather than the rule, if you're going to have people work in another generation, you do have to, I think, have a little bit of counseling where it's not just about the dollars and cents, but you do have to be able to ask the person who's running the business now, do you objectively think that your daughter or your son is going to be able to step into your shoes and handle this particular element of the business? The times when I've seen things work is when that first generation is able to objectively look at the talents as well as the limitations of their children and decide what roles that they can fulfill. There's one business I'm really happy about that it's a very kind of unique setting, but they own some aquatic products. However, the two sons get along real well, so we don't have what I call the Cain and Abel problem. And then secondly, what happens is they complement each other as far as their skill set. One is definitely the guy that does the books and is the one that's going to make sure that all the appropriate financial decisions are made. And the second is the one that is really great personality. And I mean, he certainly works hard, but he's the one that goes out and develops and maintains existing client relationships and also is able to deal with the various vendors and people. So they really, and unfortunately, that worked out well. And the parents also were able to push them into it because one of the gentlemen actually wanted to do one of the other jobs, but after sitting down, they realized, that they definitely belong in the two slots. What happens oftentimes is parents just want the business to survive so badly that they overlook what's obvious to anyone else. And I've told parents, look, you're not doing your kids any failure, but if you give any favors, if you give them a business that's going to be destined to fail, because it's not just a question of the business going over, it can have a very negative impact on their children's finances. So the other thing you have to look at is the kids that are not in the business. Um, and what you have there is I one family where there's three kids, two are active in the business, and a third is not. So the question is, how do we adjust? Sometimes you say, look, the businesses are worth X number of dollars, and so the two kids in the business will get one half of X each, and then we'll do an equivalent amount of assets that are outside of the business that would wind up going to the person who's not working the business. When you do that, you have to look at two things, however. One is, are we going to pass on the business as a fair market value to the kids? Sometimes you have to evaluate what is the contribution that children have made. Sometimes they're getting paid just like anybody else in any other sector. Sometimes they work at what I call the family discount. And sometimes you need to adjust that. So it's something that you have to really, really ask a lot of questions and dig into. And then what happens is you need to take care of that in the business agreements, but you also need that to be reflected in the estate planning agreements as well. For example, the case I just gave you, we have inside the particular trust documents that, upon the death of the primary owner of the business, that there will be a valuation made of the business and that there's a formula to discuss how much the individual is going to receive that's not in the business. And it does have a combination of, um, trying to make things equal, but understanding that there has been some sacrifice by the two that have, contributed. But it's pretty black and white.
I want to know from you what the differences between owning a business personally versus holding it through an entity like an LLC or a corporation. How does that impact estate planning?
So, I mean, if you hold a business personally, it's in one of two capacities. One as a sole proprietor, or if you have people that you're working with, a partnership. And they're very easy as far as taxes. You just report stuff on your own return. If you're going to get the business a name, you just get a trade name, and it doesn't give you any sort of, you know, you know, it gives a nice look to it, but doesn't give you any corporate protection. But the downside, why people generally avoid being in partnerships or sole proprietorships, is that we have, as for many decades now, an increasingly litigious society, and someone wants to make sure that there's a legal action filed against them, that their assets are not exposed. I mean, when you get to very, very complex structures, corporations often make the most sense. However, more often than not, I recommend the use of a limited liability company. Uh, for lack of a better term, it's one of those areas in the law where you can seem to have your cake and eat it too. From a tax perspective, you get taxed like an individual, so you don't get the double taxation of a corporation. On the other hand, you do get the corporate protection. And that's important. One of the biggest things I see from time to time is people that invest in residential real estate, for example, and they have tenants. And the concern is that if there's a accident, and to the extent it's not covered by insurance, people want to make sure that there's a lawsuit that is limited to the assets of the business. Because let's say, for example, I own a house that I rent out, and there's some horrible thing that happens. My insurance doesn't cover all of it. Well, let's say there's a judgment that exceeds it by $1 million. Well, I have to pay the $1 million if I'm owning it individually or with a partner. However, under a limited liability company, uh, they can go after the equity that I have in the real estate because it's owned by the LLC, but they can't go after my personal assets. And they're relatively inexpensive they're reasonable to set up as far as cost. So it's kind of like what I call one of the insurances to the inheritance.
You touched on earlier um, certain insurance plans that are in place when it comes to buyouts and such. I'm wondering if you can speak a little bit more about how life insurance policies or cross purchase agreements help business partners and family members keep the business running after someone dies.
To the extent that it's possible or practical, when a business starts, everybody should take a look and see whether their particular partners are insurable. Uh, and at the what I've seen happen over the years is if somebody's not insurable, we try to make a plan B. Uh, One thing that I've seen people do is they'll set up a side fund just to realize that if somebody drops dead, there's some upfront money that's going to wind up going to the family. So once again, if you have two partners in the LLC or the business, and the older one has some medical conditions which makes him or her uninsurable or the cost too prohibitive, then the idea is to set aside a little bit of the profits so that when the person passes away, that there's at least some payment, if not all the payment, that can wind up going to that survivor, and then also it doesn't cripple the person who's going to try to continue the business. The thing that I find is that even if it's expensive, you try to get some insurance. And then what I generally have is a blended agreement, which basically says that, using the earlier example, say we're going to do a buyout over like 5 or 10 years, that if to the extent there's insurance, that the insurance is used initially, that we're not going to give it to the business and the business owner hold on to it and use that as part of the payout. And that's important because one thing that is a risk frequently is that when somebody passes on, the survivor may or may not keep the business alive forever. There could be circumstances where it's nice to know that you have a note for the business. On the other hand, if the note doesn't get paid back, the person who's probably running the business doesn't have the individual capacity to pay it back either. So one thing I do insist is that if there is insurance, that the entirety of the insurance be used to pay for the purchase price.
A little bit of time we have left here. I want to, for people, anyone who's listening, right, who hasn't done any planning but owns a small business, what's the best first step they could take to protect both their company and their family if something unexpected happens? What's step one in that thinking?
So there should be, two steps. One, make sure that the buy-sell agreement is realistic, that it
Okay.
can cover not just death, but retirement also, as you inferred, disability. Because
Hmm.
sometimes the question is the person wasn't going to retire, but they're incapacitated and cannot work. The second is not just to talk about the financial terms, but talk about the management terms as well. A lot of times, individuals will have powers of attorney to allow, their spouse or one of their adult children to step in and manage their personal and financial affairs if they're incapacitated. But, uh, the business partner may not want to deal with the spouse or the children. So oftentimes when you do the planning, you want to have some operating agreement in effect that states that if somebody is incapacitated, whether the surviving partner or the remaining partner is going to be responsible for handling everything, or in the alternative, is there's somebody that would be appointed to step in to handle those affairs. And even if it's going to be the remaining partner taking care of things himself or herself, you want to make sure that's expressly stated, because every so often I've had the occasion where, once again, we had the bare bones planning, and one partner got sick, and their spouse decided it was time for them to step up and try to work with the partner who was actively engaged in the business. And this partner was well intended, but had absolutely this partner's spouse was well intended, but had absolutely no idea how to participate in the business. But it was enough to create a lot of discord.
Yeah, that's good stuff. Well, listen, Tom, great to talk to you as usual. And I'm sure we'll speak again in the future.
Look forward to it, Sean.
That's it for today's episode of the Estate Blueprint with attorney Thomas D. Begley III. To learn more about Tom's work in estate planning, trust administration, and business succession, visit begley3law.com. You'll find resources there to help you protect your assets, preserve your business, and plan with confidence. Thanks for listening. I'm SeanOConnor. Don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.